afternoon. On behalf of Arthritis New Zealand, welcome to our latest webinar, which focuses on employment issues. We're delighted to have presenter today Hannah McMillan from Bell Gully join us. Just a quick word, if you do have questions during this webinar, if you go to the bottom of the screen, you should have a function bar come up and it has a chat box, and you can type in a question which we will then pick up and pass on to Hannah. So Hannah, thank you for joining us. Over to you.
Thank you, Francesca. So like Francesca said, my name is Hannah McMillan and I'm a solicitor at Bell Gully in the employment team. So I'll be presenting this webinar today, and we're going to talk about broadly what do I have to tell my employer, what responsibilities does my employer have towards me, and what rights do I have. But just before we start, I'd like to alert your attention to the disclaimer at the bottom of the slide. So this presentation is a general guide and does not constitute an authoritative description of the law, nor does it replace professional legal advice. So you should seek professional advice before taking any action in relation to the matters dealt with in this publication. So as we know, disability and chronic health issues are main obstacles to keeping employment for thousands of New Zealanders. Some of the issues at work are, some of the issues people with disability and chronic health issues face at work are needing time off for specialist appointments, using up sick leave, negative perceptions of colleagues and bosses, and the physical demands of the position. So what can really help with these issues are investment in policy and employment changes. For example, having employment policies that create a safe working environment for people with disabilities and chronic health conditions. So turning now to our first question, do I have to tell my employer that I have arthritis? You are required to disclose a health problem or disability to your employer in two situations. So the first is if it could cause health and safety problems in the workplace, and secondly, if it could prevent you from suitably performing the responsibilities and duties of the job. So on a job application and in an employment interview process, you should be honest about your condition and answer any questions about your condition truthfully. If you are dishonest, a job offer can be revoked or you could be dismissed from the job. So that's where transparency is really key during that interview process and job application process. Additionally, your employment agreement may include provisions that require you to keep your employer informed of health conditions. So continuing on with our first question, your employer has a duty to provide you with a safe and healthy workplace, and therefore your employer must be made aware of any circumstances that might give rise to harm in the workplace, such as your arthritis, if that is applicable. You do have a duty of good faith to your employer, which means you must be responsive and communicative about any health issues you are experiencing where it is relevant to your work. For example, you cannot complain of a lack of support from your employer at work if you have not advised them that you need that support and why. But take into account that you may feel worried or unsure about telling people at work about your arthritis. But it can be beneficial to tell them, because the sooner you talk to your employer about your arthritis, the earlier they can make reasonable adjustments into your workplace, and the easier it could be for you to manage work alongside your symptoms. So really explain to your employer what would be helpful to you to perform your job more efficiently. Over time, your needs may change, so therefore communication with your employer is also beneficial, as it may prevent them from forming negative assumptions about your arthritis and its effect on your work. So by way of an example, in the case of Laurie and Air Liquid New Zealand Limited, which is a case from 2013, the Employment Relations Authority found that an employer was justified in dismissing an employee who was absent from work for 62 days in a 13-month period. And the reason was that the employee was not forthcoming with medical information. So that employee had suffered depression, but did not inform the employer of this until 10 months into his employment, and after he had been absent for more than 15 days. So providing medical information about his condition to his employer would have assisted the employer in dealing with how to deal with the employee's absence. So as another example, we have another case recently from 2018, and it's called FGH and RST. So the employment court found that an employer cannot discipline an employee for poor behaviour and or performance that is caused by an underlying condition until the employer has explored and identified the underlying condition and worked with the employee towards resolving it. So for an employer to be aware, however, the employee must be an active participant in all the processes and disclose the condition. So we have a piece of legislation called the Privacy Act 1993. So there, any personal health information you disclose to your employer for the purposes of, for example, setting up a more comfortable workplace is protected and must be kept confidential. Your employer must hold that personal information and not use it or disclose it for any purpose other than the one for which it was originally obtained. So for example, setting up a more comfortable workplace. Your employer should only share your personal health information with your colleagues if you have given express permission, and only if it would not result in some kind of unjustifiable disadvantage to you. Moving on now to our second question. What legal responsibilities does my employer have towards me in relation to my arthritis? Your employer has legal responsibilities to you under their duty of good faith provisions in the Employment Relations Act 2000, and also under anti-discrimination provisions in the Human Rights Act 1993. Your employer has a duty to act towards you in good faith. And this means that your employer must engage appropriately with you when it comes to your arthritis and how it may impact your ability to work. Your employer must take steps to support your ability to work, and this might include implementing workspace and occupational assessments. If necessary, your employer should seek and consider any relevant medical information from you, and should also explain to you any reasons for any inquiries into your condition, including possible outcomes. Your employer should always give you the chance to provide your input and comments. And with regard to that, your employer also imposes you additional obligations under the Human Rights Act. So the Human Rights Act defines disability as including physical disability or impairment, physical illness, and any other loss or abnormality of physiological or anatomical structure or function. And arthritis is a condition that in many cases has a substantial and long-term adverse effect on a person's ability to carry out normal day-to-day activities. So this means that while you may think of yourself as ill rather than disabled, having a long-term illness that adversely affects daily life may be regarded as a disability for the purposes of anti-discrimination laws. So under the Human Rights Act, your employer is prohibited from treating you less favourably than others by reason of your arthritis. Your employer is also obliged to reasonably accommodate your arthritis. So this means that where reasonable, your employer is required to provide special services or facilities that enable you to perform your duties satisfactorily. But the Human Rights Act does not specify the special services or facilities an employer must provide. However, depending on your disability, it could include, for example, special travel arrangements to and from your workplace, specially designed chairs, desks or workstations, secretary or assistant, a palliative or therapeutic device, or an auxiliary aid. So for people with mild to moderate arthritis, the earlier the adjustments in the workplace are made, the easier it will be for them to remain productive. And what amounts to a reasonable accommodation depends on a number of factors. Your employer's obligation to you will be determined on the merits of your unique case. And therefore some exceptions do apply, which we will talk about later in the webinar. So those questions that we will talk about later include, is it reasonable for my employer to accommodate my disability? My arthritis could cause harm to myself or others in the workplace, and therefore what rights would I have? So those questions we will touch on later. But firstly, by way of example, we have a case called Atsley and Southland District Health Board from 2009, where the accommodation of an employee's disability was also consistent with the employer's contractual obligation. The employee's collective agreements provided that the employer would ensure disruption, personal health effects and fatigue associated with shift work are minimised for the group of workers involved. So what we can take from this is that employees should check their employment agreements when considering what duties they and their employers owe to one another. So now on to question 3. Does my employer have to accommodate my disability? So the main purpose of this section is to talk about the exceptions in the Human Rights Act. And so there are exceptions in the Human Rights Act to an employer's duty to accommodate an employee with a disability. So your employer may treat you differently on account of your disability if you can only perform the duties of your position satisfactorily with the aid of special services or facilities. And therefore, it would not be reasonable to expect your employer to provide those services or facilities. And of course, every case is different and your situation will be considered on its own facts and merits. So I want to refer back to the case I mentioned just before, Atsley and Southland District Health Board from 2009. So this is where an emergency department nurse was required to work rostered night shift. She suffered bipolar disorder and began to experience difficulties at work. A medical professional confirms that her condition was not compatible with working intermittent night shift and suggested that a mixture of morning and afternoon shifts instead of the night shifts would allow her to continue her work in the emergency department. Several nurses offered to cover her night shift. So the Employment Relations Authority found that limiting the employee's roster to day and afternoon night shifts and having other employees cover her night shift duties would not be unreasonable disruption for the employer. So question 4 says, what rights do I have if my arthritis has caused harm to myself or others? So every employer owes a duty to ensure the safety and health of its employees and to provide a safe working environment. This means that your employer must also treat you differently on account of your disability if the working environment or the duties are such that your arthritis means you could only be employed with a risk of harm to yourself or others, and it is not reasonable for the employer to take that risk. However, this does not apply if your employer could, without unreasonable disruption, take reasonable measures to reduce any health and safety risk that your arthritis may pose to a normal level. So again, there are exceptions, and every case is different, and your situation will be considered on its own facts and merits. But as an example, we have a case called Wilson and Sleepyhead Manufacturing Co. Limited in 1992. So this is where an employer dismissed an employee who had an epileptic seizure at work. He had had one other seizure at work a few weeks earlier. The seizure took place on the work floor while machinery was operating. So the employer was concerned at the danger to the employee and to other employees should another seizure occur without warning near moving machinery or while working at a height. So the employment tribunal found that the employer's concern about safety was justified, and the dismissal on notice was within the range of justifiable actions that the employer could have taken. So what we can see here is that health and safety is a critical aspect to whether a person can work at that workplace. So for example, if you have arthritis, which affects your ability to do heavy lifting, the employer may choose not to hire you because it could cause health and safety problems to not only you as the employee, but also to other employees. And especially where the job description requires you to do that heavy lifting, it's a main part of that to do heavy lifting, then it's reasonable for the employer to choose not to hire, where it can of course show that there's a real health and safety risk. So as another example, in Lea Lau Gata and Tamatahu Limited, this is the case from 2013, an employee with severe arthritis of both knees and heart problems was dismissed from employment. The employee's arthritis prevented him from heavy lifting, any fast activities, walking long distances, or going up and down stairs. This lack of mobility made him unable to undertake the essential duties of his job, including tracking and restraining clients who all had intellectual disabilities. And therefore the employer was concerned about his health and well-being and the safety of the people he was supporting. The employer considered there was no realistic prospect of any alternative duties being available to the employee. And the employer decided to terminate the employee's employment after a fair and extensive process. So that fair and extensive process took around 7 months. So the Employment Relations Authority found that the employee's inability to undertake a full range of duties of his position compromised his own safety and that of his co-workers. The employer could not, without unreasonable disruption, take reasonable measures to reduce the risk to a normal level. Question 5. Do I have to disclose my arthritis on a job application or in a job interview? So the main question here, and what I'm going to talk about, is the Human Rights Act again. And so this act protects the interests of people who have a disability from discrimination in the workplace, except in very specific circumstances. Potential employers should not ask health-related questions of you. You're not required to disclose a health problem or disability to a future employer unless it could cause, once again, health and safety problems, and or it could prevent you from suitably performing the responsibilities and duties of the job. So on a job application and in the actual interview process, you should be honest about your condition and answer any questions about your condition truthfully. And if you are dishonest, a job offer can be revoked. And if you were to be employed subsequently, you could be dismissed from the job for not being truthful. So by way of an example, we have another case called Imperial Enterprise Limited and Atwood, and this is a case from 2003. So the employment court found that a question in a job application form that asked the applicant to disclose any medical conditions was discriminatory on the grounds of disability, and therefore it breached that Human Rights Act. But we would like to note that, however, disclosing your arthritis and its effects on your ability to work does let your employer or your future employer know what they need to do to make the reasonable adjustments to the recruitment process or to support you in the workplace. So question 6, do I have to give my employer a doctor's certificate as proof of my illness? I think the first things first, check your employment agreements. This will specify what you would have, what you have agreed to do. So I think in short, your employer may request a medical certificate when you take sick leave. So if you've taken sick leave for less than 3 days, so 2 days, the employer must pay for it. But if you've taken sick leave for 3 days or more, the employer doesn't have to pay for it, and the employer can require you to obtain that medical certificate. So the employer may request a medical certificate to prove sickness or injury when you take sick leave. If your sick leave has been less than 3 days, your employer must inform you as early as possible that medical certificate is required. And this is typically set out in a standard employment agreement. But having said that, all employment agreements are different. And if your employer has requested that medical certificate where you have been sick for less than 3 days, then the employer must pay reasonable expenses for you to obtain that certificate. But while your sick leave has been more than 3 days, your employer is not obliged to inform you early or to pay those expenses of obtaining the medical certificates. I would also just note that there may be additional requirements for proving your health in your employment agreement. So like I said, every employment agreement is different and depends on what's contained in that agreement and what you've essentially signed up to. So for example, an employment agreement may require an employee to establish that there are no relevant health or safety reasons that prevent him or her working. So like I said, it's all dependent on what the employment agreement says. So question 7, can I leave work for doctor's appointments? I think in summary, yes, you may use sick leave to attend those doctor's appointments. And in relation to sick leave, all employees are entitled to at least 5 days sick leave per year. So that is the minimum entitlement. And usually the minimum entitlement is that once you've worked for 6 months, you obtain 5 days of sick leave thereafter. But once again, it all depends on what your employment agreement says, because some employment agreements don't have that requirement and they give you 5 days sick leave as soon as you start work. Some require you to wait 6 months before you get those 5 days, and some may give you more than 5 days. So like I said, it's all dependent on your employment agreement. And as it says on the slide, you may be entitled to more sick leave under your employment agreement. So there's also another point up on the slide that says, yes, you may ask for additional leave if all sick leave is used up, but the employer does not have to grant you leave. having said that, it is good to get more information to your employer to understand why you are requesting that leave. So the more information, the better. So I think just to say again what I've just been talking about. So you may use sick leave to attend your medical appointments in relation to chronic arthritis. And all employees in New Zealand are entitled to those 5 days sick leave per year after they've worked for 6 months, one employer. And like I say, you would really need to check the terms of your employment agreement because they may provide more than 5 days. And yes, it's very employment agreement specific. So in terms of carrying over sick leave, up to 15 days of sick leave may be carried over from 1 year to the next. And this is up to a maximum entitlement of 20 days sick leave entitlement in any 1 year. So again, it depends on what your employment agreement says and what it allows you to carry over and whether you can carry over more than this for the next year. In the event that you have used up all your sick leave and annual leave, your employer is not obliged to provide you further leave for medical appointments. I would say that, however, they are obliged to be reasonable and act fairly towards you. So the more information you provide your employer about your medical situation, the more likely they are to be understanding and allow you flexibility to leave the workplace. If you have ongoing and recurrent medical appointments, you may consider approaching your employers about flexible working arrangements. So these flexible working arrangements, you would have to apply to your employer, and they would have to get back to you within a specified amount of time whether they will allow you to work flexibly. So where could we get some more information? So we have Arthritis New Zealand's website. We have their phone number, 0800 663 463. Their website you can find by typing Arthritis New Zealand on Google. And if you do choose to speak with an arthritis educator, you can just phone that number. There's also other information you can find on the internet. The Ministry of Business, Innovation and Employment has a very useful website. It's www.dol.govt.nz, and I believe the updated website is www.employment.govt.nz. I would note, however, that typing in www.dol.govt.nz will get you to Employment New Zealand anyway, but it won't get you there directly. You'd have to go via Google. But just in terms of information about MBIE's website, it is very useful. It contains a lot of information about your employment entitlements, your employment rights, and just general information that is very useful for everyone. There's also the Human Rights Commission's website. So they outline your rights in New Zealand as outlined in the Human Rights Act that I've been talking about before. So their website is www.hrc.co.nz. You can also call them, and they have a phone number on their website. So usually the Human Rights Commission is where people would lay complaints about potential breaches of human rights, and the Commission will usually talk you through the process there. So they are a useful avenue if a dispute should arise. So we also have the National Equal Opportunities Network, in the website is there on the screen, www.neon.org.nz, so neon.org.nz. And we also have the Office of the High Commissioner of Human Rights there as well. So now moving on to some questions. So our first question is, does the requirement to make reasonable accommodation apply to contractors or individual or casual employees. So contractors are actually not employees. So they don't have an employment agreement with the employer. They are contractors to perform a specific function, but they don't have the same entitlements as one would have under an employment agreement, because contractors usually pay their own PAYE, they do their own taxes and ACC and all these other things. So the requirements to make reasonable accommodation, I would say, is the contractor would need to talk to the employer, to the company about that, because the company isn't the employer. But in relation to casual employees, they are employees under an employment agreement. So the employer would need to make reasonable accommodation for that casual employee. I'd just like to say though that it all depends on the facts and circumstances, but generally, yes, contractors are not employees and therefore don't have the same entitlements as employees. So another question. As soon as I mention I have arthritis, employers lose interest in hiring me. What should I say to them? I think it's always a question of, do I have to disclose this during the recruitment process? And the answer is no, it doesn't. No, you don't, but there are the two scenarios I mentioned earlier before, if it could cause health and safety problems in work, or if it could prevent you from suitably performing your job. So if you think that your arthritis is not going to cause any health and safety problems in the workplace to a normal level, then it's probably not necessary to mention it during the recruitment process. And I would also say that employers can't discriminate against potential employees, prospective employees, on the grounds that the person has arthritis. They would have to have genuine reasons, and they can't discriminate on the grounds of disability. So in terms of what you should say to them, it all really depends on the circumstances and the facts. If the employer seems to be losing interest, is this the right employer for you? If this employer, because I think it's simply if they're not interested because of that fact, then it may not end up being the right place to go, and then maybe it's better to look elsewhere where someone would be more accommodating. And even during the recruitment process, if you say to them that you have arthritis, employers should be amenable to putting in any workplace adjustments that you may require up to, of course, the normal level to help you with your arthritis. So it's always a judgment call on what you should say to them, and it's all very individualized and depends on how the person coming back to you, and what's the feedback you're receiving from that potential employer, and whether you should be working for them.
And this brings us to the end of our webinar. Just to reiterate, if you have any questions about arthritis, please do feel free to call us at 0800 663 463 to talk to an arthritis educator, and you can view this webinar on our website at any time. Thanks for joining us, and we hope you found this useful.